welcome to today's episode, another great discussion, topic, and program assembled by Active Prospect today to help the lead generation and performance marketing industry navigate the most recent FCC one-to-one consent rules, CMS Medicare consent rules, record-keeping requirements, and the related updates to the TCPA, or Telephone Consumer Protection Act. We hope today's discussion will help you translate these changes with more confidence and a focus on compliance. Today's topic, harmonized compliance, consent strategies for CMS Medicare and TCPA one-to-one consent capture. First, some housekeeping information. In our webinar platform, there is a chat icon and a questions icon. We encourage you to ask questions throughout the session today, and please use the chat section for general comments and interactions with other participants. And please use the question section if there are items you would like us to answer. We will leave time at the end to review and respond to your questions. Also look for the poll section, as we have a few insightful questions we want to ask you in the audience today. So finally, look for a brief survey at the end of this webinar, and we encourage you to share your feedback and include any topics you would like us to explore in the future. And a link to today's recording will be emailed out tomorrow morning for your reference and sharing with your colleagues. Hello, I'm Benjamin Farrar. I'm the Director of Privacy, Security, Compliance at Active Prospect, and for the past 20 plus years, I've worked for companies in the performance marketing and market research space, including Tinson and WPP Kantar, as well as Ernst & Young in New York and Ochsner Clinic Hospital in New Orleans, Louisiana, mostly focused on data privacy, data regulation, compliance, internal auditing, and information security. During my time at all these industries and jobs, many significant data regulations were passed, and I was on the team responsible for reviewing these new rules, working to seek clarity and establishing a compliance program. And now for a brief background and introduction, I'd like to pass the mic to our first guest today, Chris Dethridge, General Counsel at Apollo Interactive. Chris.
Hey, everyone. Chris Dethridge. I've been with Apollo for about 5 years. We typical lead generator, clicks, calls, transfers, leads, just about anything you'd want. We operate heavily in the Medicare space, working with carriers directly and both through aggregators. So we've been in the thick of this.
Excellent. Thank you, and happy you're joining us today. And also John Henson, attorney at Troutman Amin. John.
Thanks for having me, Ben. I am John Henson. I'm an attorney at Troutman Amin. Joined the firm in February. Prior to that, I was general counsel at Consumer Affairs. And prior to that, I was at Linktree for 8 years. Did compliance there, led the legal department for a while, and then also worked in the mortgage vertical as a general manager there. So been in lead gen for a while and excited to talk to you about this today.
Excellent. Yeah, we're excited too. Some real subject matter experts here. I know you all really dig into the details of this topic here. So let's start with what happened. What are these new CMS requirements? I know we're going to particularly be talking about the one-to-one consent and data sharing needed. But John, if you can just give us a run through quickly of some of the CMS requirements that were announced in April and are about to go live in October.
Sure. So in April, CMS released their annual final rule for the upcoming year. This year they looked at third-party marketing organizations, TPMOs, and the sharing of personal beneficiary data. Personal beneficiary data is the information you gather when you're trying to fill out a lead form. And the sharing of that information with TPMOs, we put a definition on the screen there. Any TPMO that collects personal beneficiary data has to have that beneficiary's prior express written consent before they can share that data with an additional TPMO. And you'll see from the definition of TPMO, it's very broad, and it's basically, as we jokingly said, everyone involved in the chain of enrollment, up to the carriers. So it could be a first tier TPMO, could be even downstream. Anyone in the chain has to get consent from the consumer before sharing that consumer's information with the TPMO.
Okay, excellent. And for those that aren't as familiar, this whole sort of relationship of the Medicare or CMS and connection to the insurance carriers and TPMOs. Can any of you just run through that whole ecosystem so those can understand that this interrelationship between them?
Yeah, so essentially, how that breaks down is you have carriers that contract directly with CMS, with Medicare, and then they have any types of sales agents, brokerages, or marketing agencies, or what have you, that actually conduct this whole chain of enrollment marketing for the carriers. Most of these carriers, they don't handle a lot of this in-house; they kind of outsource it. So the way CMS is able to exert control under their powers is they exert it over who they're contracted with, which is the carriers. They don't really have direct control over carriers, marketing affiliates, or necessarily the field marketing organizations or anything like that. So they exert that same level of power through the carriers by, in their regs, levying these requirements against the carriers, and then saying you also have to enforce it on the TPMOs that you do business with.
Yeah, I think, Chris, you touched on it briefly there for a second, but it's also important to remember that because it says marketing organizations in there, I think a lot of people believe that that's like people who are out there buying display ads or SEM ads, but it's also insurance brokers, right? Those are also included. So if you're buying traffic and you're selling it to a broker, that's a TPMO to a TPMO relationship, and those are the kind of relationships that we have to get the prior express written.
And there's a key compliance date coming up right around the corner in this space, correct?
Yeah, it's October 1st for the 2025 plan year. And, I know we're going to talk about this more, but that is 4 months ahead of the TCPA 1-to-1 consent deadline of January 27th. So if you are in this space and you have not figured out how to get 1-to-1 consent, you're running out of time. You need to be looking at this now. Not only for that October 1st deadline, because it's important, but any leads you contact or any data you're sharing after October 1st has to have that prior express written consent. So if you're waiting till October 1 to turn it on, you're going to have those leads come in, and you're starting with a fresh pipeline. So if you know that your sales cycle is 3 to 6 weeks, you need to start getting that prepared now. So come October 1st, you have people to call, people to transfer their information.
Yeah, absolutely. And we're doing our best to make people aware of that. I think a lot of individuals were focused on the FCC changes with their 1-to-1 consent, and those that are in the Medicare space, since they referred to it. But it's coming up now, and discussions need to be being had in this space. And so it's critical if you haven't had those discussions or even getting closer to finalized plans. But so how can these CMS 1-to-1 consent requirements and the TCPA, how do these two interact? Where are they the same? Where are they different? If you can help explain and articulate that would be great.
So the TCPA 1-to-1 consent is going to require each consumer to give consent to a single seller at a time. That can be done a number of ways. What we're seeing a lot is checkboxes where it says, I consent to have seller A, seller B, seller C contact me, and the consumer can go in and select those sellers. So that's the TCPA one, and it's coming up in January, as we said. CMS is saying the same thing, and in the rule, it even references the TCPA changes. And basically, that this is going to go hand in hand with that, but the difference here is that the TCPA changes are for the ability to call the consumer, whereas the CMS changes are for the ability to share the data with other TPMOs. So there is a distinction there that I think is important, because it's not just for the consent to call.
Right. Yeah. And it's important to also make a distinction too that the TCPA focuses on the definition of a seller, right? Which it's very different than the definition of a TPMO under CMS's rules. In a lot of instances in this industry, the seller will not be a TPMO. In the insurance space, the seller is frequently the entity that writes the policies, right? You're talking about Humana, UHC, Anthem, or Elevance, all these different carriers, whereas the TPMO is never a carrier. The TPMO is the actual agency that's going to be enrolling the beneficiary. So that's kind of like a little disjunctive point of contention between the two rules.
Yeah, that is interesting to call out because now I'm used to interpreting the language of the TCPA with their updates of one-to-one consent. And when they say seller, translated to the good and service company, right, at the end, who's going to be providing something. And in this perspective, it's the Medicare program, which is provided by the carrier, right? So it is interesting that even though they refer to as it the same, it's actually not exactly the same when you're really getting down to the technical details of who's being identified on the web form and the one-to-one consent and naming those parties and things. It's not as straightforward or just a rinse and repeat of what you were getting ready to do in January.
Yeah, and I think to your point, it's identifying who you're consenting to and what are you consenting for them to do, right? I want Aetna to call me about my life insurance plan. I consent to have Apollo share my data with company X, right?
Yeah, and now it might be good time for our first poll. We wanted to sort of identify, because we have different individuals in the audience and doing lead generation in slightly different ways, but this will help frame the rest of our conversation. There's a poll icon on the right section there. So for our first poll, what type of lead generation traffic will you be focusing on? Is it A, data leads, B, outbound transfers, or C, inbound calls? And we wanted to ask this because to see where our people are going with this, but also the obligations and the requirements are somewhat slightly different in this. So check the poll question for that, in which the area in which you're going to be performing, and we'll circle back in a few minutes and take back the inputs from poll question there. Chris, I know you've been digging in very close in detail because you're implementing these solutions for Apollo Interactive. So what are some of the other most important things that individuals or even the marketplace is not aware of? Because you all play a critical role in that sort of communication chain between this group. So what are you seeing and what do people need to be made aware of?
Right. So what people really need to keep in mind is it's not just like, oh, I'm going to implement a new form with whatever my strategy is and then just sell it off piecemeal, whatever leads or whatever calls I'm generating. You really need to make sure that you're synced up with your buyer base and maybe if you're an aggregator, your source base. And the reason being is because unlike the TCPA, where you just get end consent for a seller, it doesn't matter who it passes to as long as the seller is the one calling, right? CMS, it's all about data transfer. So how many TPMOs are in that chain, you need to figure out how many entities in my current funnel do I actually need to get consent for. If there's too many entities in between the end caller and the point of generation, it may not be feasible to actually collect one-to-one TPMO consent for all those entities. So you're really going to have to look at your funnel and say, who does this actually need to pass through? And what names do I need to display?
I agree wholeheartedly. And I think that it's a situation where, and this is what we tell clients a lot, is you really have to understand your lead flow and what happens, because now it's not just, oh, I know it's going to end up with a big lender or a big insurance company. It's how's it going to get there, and how do we make sure that those people are protected, and that we are protected as the lead generator as well. I've said the other day to someone that a lot of this is just good third-party vendor management, and I think it's clear that it is still a lot of third-party vendor management.
Yeah, absolutely. Let's go back to our poll to see where the results, to see where individuals are split up. And so the number has interesting split. So 42% responding saying they're going to be relying on data leads. All right. 43% of that, so very similar, on inbound calls. And then right at 15% for outbound transfers. So that's the sort of split there. Data leads about half, inbound calls about half, and then 15% for outbound transfers. What do y'all think of the results of that, or how that segments? Is that as you all expected?
Yeah, that's about what I was expecting. That's what I've been hearing from other players in the industry. I would say inbound calls are probably the safest, easiest avenue to go, particularly because in the rules, CMS clarified that you can still do a data transfer on an inbound call as long as it's a one-time transfer to the entity that's going to help the consumer with whatever their need is, without needing that prior express written consent. So they give you leeways in that scenario that you don't really have when it comes to data leads.
Yeah.
The downside of that, though, is you don't have the convenience of a data lead where you have that consumer's data right there, and you can call them when it makes sense for you as an organization. So, there's a give and take for both types of products, but the requirements on both are very different.
Yeah, I would say that also tracks what we're seeing in the market generally, especially in this industry, is the data leads and calls being the vast majority of the industry.
Okay. Chris, tell us a little bit more about Apollo Interactive. Like I said, you all have a crucial part in this whole industry and space related to Medicare lead generation and enrollment, because you all are going to be hosting landing pages that from the beginning process, start the lead generation process to passing it on. So tell us a little bit more about it.
Right. So as an organization, we've been testing and updating our forms to accommodate. We're leaning towards like multi-party checkbox consent forms right now in our tests. And it's going to be a process of, our potential buyers who are interested in that consumer will pass us whatever legal name or relevant, consumer-facing name that they want the consumer to see. We will populate in that form on a non-pre-check form, which is an important point. Unlike the FCC and FTC, where they didn't say you can't pre-check forms, CMS's rule says no pre-checking. The default has to be not to share the consumer's data. So that's kind of the avenue that we've been looking at, that we've been going for data leads. When it comes to inbound calls, again, the burden there is a lot lower. If you don't connect directly to the end caller or the end product provider, maybe there's an intermediate qualifying step. You just need to get consent on the phone to transfer to that buyer. So those are kind of the avenues that we've been looking at as an organization.
Yeah, I do want to dig in a little bit more into that consent on the phone, but let's also do our next poll a little bit, and then we can go deeper into that discussion because it relates to what you were saying y'all's approach is. So next, are you planning or using lead consent web form functions with A, multi-party select in a one-to-one perspective, or B, a single party named in a one-to-one perspective? Are you C, exploring other options, or D, not sure, need some help and advice in this space? So mentioning that consent to transfer to another TPMO, let's unpack that a little bit more. If those are focused on a FCC TCPA component, that's not something that they're used to thinking of, that there is the ability to transfer, even live on a phone call. So let's talk about that more.
Yeah, I think Chris did a good job explaining it. CMS has said that if you have a consumer on a call and you can pass them to someone who can immediately help them, then you don't have to have prior express written consent to pass that information along. So I got a consumer on the call. I'm in Alabama. I can't help them, but I know Chris is in California and he can help them. I can say, hey, consumer, I can't help you. I can transfer you to Chris, who can help you. Can I send you to him now? And the consumer says yes. Then we can do that. Now, what I cannot do is say, I'm going to transfer you to Chris, but if Chris can't help you, I'm going to send your information to Ben too. Okay? You can't do that because CMS is pretty clear in its rule that it has to be that immediate assistance. And since I can't immediately transfer you to two people, it's really going down the daisy chain to get to the customer, get the consumer the immediate help that they're looking for.
Right. Yeah. It's important to note that CMS is not saying getting that consent on the phone is prior express written consent. They're saying the opposite. They're saying it's not prior express written consent. We're saying prior express written consent is not needed in this one specific situation.
Yeah.
Okay. Yeah, that is an interesting, specific item, because I think someone would probably just look at it and say, oh, this is allowed. This is how we're able to get consent. It's more defined than that, where it's allowed or not allowed. That's really interesting.
Then you also run into the issue that overall have TCPA on top of that. So let's go back to my scenario. I can't help you. Chris can help you. Okay? I can send you to Chris. But unless you specifically have agreed to have Chris call you from a TCPA perspective, Chris is going to have to gain that consent on his own. Right? He's going to have to do it over the phone, which you can't do. So he's going to have processes that will allow him to get the consent in the appropriate manner, even though you've consented to talk to him already from the CMS perspective. So that's when this gets a little tricky, and we're seeing this a lot with clients saying how we're going to do this, right?
Yeah.
So you've got to come up with some ways to make sure you make that initial handoff. But how after that handoff, how can that TPMO continue to work with that consumer?
Correct. And it's important to note too that in the TCPA context, you might make the argument of like, oh, well, I'm not going to use an auto dialer. I'm not going to use a pre-recorded or artificial voice, and I'm going to scrub against the DNC list. If you're not on there, you're fair game. That is not true for CMS. CMS's regs explicitly do not allow unsolicited contact, period, full stop. It doesn't matter about whatever type of technology, whether you're manual dialing or not. So if you're going to be outbound dialing that consumer, you need to have some type of permission to contact.
Yeah, absolutely. Let's go back to our poll question, get some results of that, and see how that was split up. So our question was, are you planning or using lead consent web forms with multi-party consent, single named party, exploring other options? Let's see. All right, got the results there. So interesting split there. So multi-party consent was 33%, single name party 33%, exploring other options 10%, and not sure, need help or advice 24% of the audience. So interesting split with multi-party and single named party. What's y'all's thoughts and comments on that sort of splitting between those two?
I would say that if you said not sure, need help, you better get John's phone number. He'll set you up. He'll set you straight. But I think it's interesting to see a pretty fair split between particularly the multi-party and the single party, because I kind of feel like those are very different business models. that are going to involve very different cost analysis between not just the buyer, but also the lead provider. Because, if you're only generating one party, can they even reject the lead if they don't like it? Because you couldn't have passed them any of that beneficiary info before you got the consent for that party. So how do they even know if they exactly want that beneficiary or not? So that's going to be an interesting thing to figure out.
Yeah, and I do want to highlight that we're talking about this in the CMS concept, because the multi-party stuff in lead generation is a more viable option for forms. But in this specific instance, yeah, it would be more complicated. And let's kick off another quick poll question, and then we'll look at the results for that. So next is, are you planning or using multi-party consent web form functions with A, pre-checked, so all party are named and all pre-checked, B, unchecked, but with a select all function? Are you exploring other options, or again, not sure, need some help, advice in this area? So digging in a little bit deeper into the multi-party and then the pre-checked or unchecked considerations. I know we mentioned this a few moments ago, but what's the position in CMS of pre-checked boxes or pre-checked names on a web form?
No.
No. It's just a hard no.
I would say that I think that the basis is it's a hard no. However, the language says the default is the consumer has to make an affirmative step. Now, I think Chris and I would agree that the unchecked checkbox and having to check it is an affirmative stance. I think you'll also hear other people who will say, oh, the affirmative action is clicking select on the call to action button. I think I would probably disagree with that. But I could see people taking this.
Yeah, I think while I think these rules were not well written at all, I do think that it was very deliberate, the wording that they chose in that explanation of the default is to not share the data. I think that was a very deliberate choice of wording.
I wholeheartedly agree.
And John, what are you seeing clients? What are the common questions that they're asking you in around this space, and the advice that you're providing to them generally? Is there a lot of mix of different questions, or people sort of asking the same things, or what are you seeing in your role?
I think some of the stuff we've already touched on has been, common questions. The pre-check, uncheck checkbox is a common question. How do I make sure my consent language gives me both TCPA consent and consent to share the data from the CMS perspective? We've looked at a lot of that. The transfers are always, as shown in the poll results, we have a lot of customers who decline to do that. The other thing that has come up a lot too, and Chris, it'd be interesting what you think about this, is there's a lot of companies in this space who rely heavily on independent contractor agents. And the reason that becomes can become problematic under this new rule is CMS looks at TPMOs as entity level. And if John and Chris are both insurance agents or brokers, and we both work for Apollo Insurance, okay, I can send your information to Chris because you've already consented. However, if we're both working for Apollo as independent contractors, I have to get the consent from you to share with Chris, even though we work for the same parent organization. And I think that we're seeing a lot of companies having to rethink how they're doing that. We have some clients who are not going to be doing data leads anymore for that to their divisions that have independent contractors, and they're just going to rely heavily on the warm transfer to those agents. the reason they can do that is what we talked about earlier, but also in their processes, when you get the customer on the phone, they answer some basic questions. The sorting machine works in the background and says, okay, I can match them with one of these 3 people. And then so I was like, okay, I have an agent on the phone who will talk to you, who's got interest, right? As opposed to a data lead situation where the consumer would have to consent to all these people ahead of time, give prior express written consent. Excuse me.
Yeah, it's interesting in the context of the independent contractor agents. You have that internal issue, but you also have the lead gen funnel issue, because when you are trying to get your name listed on the form, this is where you get that disjunctiveness between TCPA and CMS. You can't put Apollo Insurance, right? You got to put that independent contractor agent's name per CMS rules.
Yep.
But that independent contractor agent is not a seller under the FCC, under the definition in the CFR. So you're kind of, well, how do you comply with both at the same time? 2 checkboxes. I mean, that's a little confusing to me if you're a consumer, because, well, I want Apollo Insurance to call me. Who is this other guy? I clicked Apollo Insurance, but Apollo Insurance can't actually call me. The other guy was supposed to call me, but how did I know to click him? I wanted this other company.
Yeah.
So it's.
I would also say, too, that from a business standpoint, if I'm going to list Aetna, Humana, and John Henson, independent agent, guess who's not going to get picked?
Yeah.
John Henson, independent agent.
John.
So, it's, and I think, to be clear, I also think that it's going to be a downstream effect of the TCPA issue across the board. It's going to obliterate small companies. But that's a rant for a different day. So I think Chris raises some great points.
Yeah, I mean, so part of our discussion, we'll be talking about the consent web form and how important that is. So let me do a quick reference to Trusted Form from Active Prospect as the ultimate consent compliance solution for the lead generation industry. Currently, Trusted Form documents TCPA consent on digital lead capture forms for over 55,000 websites. Trusted Form helps brands document TCPA consent, and it can help you identify if the supplied lead transactions were presented with appropriate consent to contact language before your communication outreach. So Trusted Form has 3 main services. It's Verify, that helps optimize the consent capture process by enabling users to identify and categorize TCPA consent language for different lead vendors. Trusted Form Retain helps guarantee certificate availability for up to 5 years, which is crucial in TCPA inquiries and litigation defense. And Trusted Form Insights can help you make informed decisions to optimize lead buying strategies and maximize your return on investment. And coming soon, a new feature called Trusted Form Verifies one-to-one consent check. This is the new consent check feature that will allow lead buyers to programmatically check whether they or another specified company were presented consent in a one-to-one manner on the web form. So we're very excited about that. And stay tuned for announcements in the next couple of days for more information about this new Trusted Form feature. And we're happy to share a link and for information. So join the thousands of businesses that certify over 1 billion lead transactions a year that utilize Trusted Form for TCPA consent compliance documentation purposes. Where do we go from here, right? So the rules can be a little bit hard to unpack or define, but particularly if we were to look in maybe perhaps in call transfers a little bit more. Let's break those out into 3 categories. Let's talk about start with inbound calls, right? So what's the considerations for consent when there's an inbound call, someone calling in, and let's say run through the different scenarios, whether they need a transfer or whether they don't need a transfer.
Yeah, I think basically from an inbound call, right, the consumer has called you. If you're going to transfer, again, under CMS, I can transfer if the person I'm transferring to can immediately solve their issue. Under TCPA, I can transfer, but the person I'm transferring to doesn't have consent to call that person back. That person's going to have to solve that riddle. Also an inbound, I don't have consent to call that person back either on TCPA. So like if they're on my website and it says call me 1-800-JOHN, they call 1-800-JOHN and I answer, that doesn't give me TCPA consent to call me back.
Right. So a safer space from inbound calls, but definitely don't do any outreach after if anything happens that during that communication process. And for outbound calls, what's the considerations there? What needs to be gathered?
Well, so that's really where the line is kind of drawn. For inbound calls, the TCPA doesn't apply, CMS does, because we have to get that consent to transfer to the other TPMO. Outbound calls, both TCPA and CMS apply. So the calling party needs to have had prior express written consent under the TCPA to make that outbound dial to the consumer, right? Assuming you don't fall under the, technology exceptions or the DNC scrubbing, but assuming you don't, you needed prior express written consent. And then if you're going to be transferring to another party, so like let's say you operate your services as a quote finding agency, you help, or an agency finding agency, you help them find agents or brokers. You would then need to get that CMS consent while on the call to transfer them to that TPMO agency or brokerage. So you need kind of double consent in that instance. You need your TCPA consent, and you need your CMS consent.
Okay, yeah, so important to architect that from the beginning, make sure you've considered those differences, and then I'd also say use a great solution service to capture that consent, particularly if you're relying on third parties. So they might have made a mistake in the process and not disclosing that correctly, which we can help you solve that solution.
Hey, Chris, I wrote that down, agency finding agency.
I'm a marketing genius, what can I say?
Is there any opportunity for a process of sending an SMS link or an email to capture consent in these different chains in the CMS or in the TCPA space? Like someone's on the phone and then sending them a message to try to capture that prior express written consent. I know there's some caveats, but can we go a little bit further with that?
Yeah. There are caveats, obviously, but generally speaking, yes. I think there are some solutions out there or coming soon to the market to help sellers do that. You could think of a scenario where an inbound call. Let's use an inbound call for instance. Right? Like, hey, thanks for calling. I want to make sure this is a good number, and then I can call you back. Do you mind if I send you a text real quick, right, or an email? And that text or email can go out. They click on it, it goes to a TCPA only landing page. Consumer clicks it, and then now you've got the full consent, right? So that is a scenario in which that would work. And I think we're going to see a lot more of that in the future because of some of the issues we've already raised in this call, of those transfers and the ability to be able to call that consumer post-transfer.
Yeah, and of course, encourage everyone to get good legal advice in that design to make sure you're not missing something before doing that outreach, or you had the opportunity to capture the consent correctly and appropriately to allow those different types of communications and outreach. Before we shift to questions, is there any other things that we wanted to address or talk about before we, as a overview, before we go into it, look at the questions? Wanted to mention anything from either one of you?
Chris, from your perspective, because I know you have a lot of conversations with carriers, what is the carriers' what guidance on both CMS and TCPA moving forward?
Big fat zero. I have spoken to my contacts at the carriers, asking them if they have any intention of releasing any type of guidance on this, and I've been told no. They don't have any intention of releasing guidance on it, probably because they're not quite sure how to navigate it, if I had to guess. They do seem to be far more concerned with TCPA than they do seem to be with CMS's requirements, and I suspect that's because carriers are not TPMOs. So they probably look at CMS's requirements and go, not our problem.
Yeah. So talking to clients in your same space, I would say that's very consistent with what they're saying, what they're hearing. The general consensus is that carriers are more concerned with TCPA. I think honestly the big reason for that is private right of action. TCPA has a private right of action, and it's all going to flow uphill to that's the difference, really, right? It's going to flow uphill in TCPA. In CMS, the carriers can flow it downhill to the TPMOs.
Yeah.
So I feel like there's a financial risk in TCPA. However, there's a almost an existential risk in CMS of the fact that if you're screwing up your transfers and it affects the carriers, you're not going to work with that carrier anymore because they're just going to say, no, we're not working.
Yeah, that's an important point to when you're talking about complying with these two laws. The risks are very different. Regulators can come after you in one way or the other under either one, but regulators can usually be reasoned with. As long as you're complying with the spirit of the law, they can kind of cut you some slack, maybe slap you on the wrist as long as you say, I won't do it again. In TCPA, a plaintiff's not going to do that for you. They want that money. They're going to come after you. They're going to make you hurt. Because CMS does not directly regulate the TPMOs, they regulate the carriers, they're going to go to the carrier and they're going to go, hey, we've gotten complaints around this. We're mad. If the carrier finds out like, oh, I don't know, your ads were not compliant or you weren't getting proper consent or transferring properly, they're just going to say, hey, for the time being, every other one of our source entities, every agency and brokerage, don't buy traffic from this entity. I mean, carriers can outright just execute you right there. No trial, no nothing. They're not going to send you a CID or something like a regulator would, and then give you some time to respond. They're just going to blast out an email saying, "Don't do business with this TPMO."
Yeah, it would seem. Correct if I'm wrong about this, but it would seem like there's a lot of risk in the TPMO space on this. They're sort of wearing it in, and they're in the middle, right? They're a small but important part in the middle with bigger players on top, but the risk of this component of CMS and proper transfer to another TPMO really sits with them, and then starting conversations with their partners about how are we gonna get this done, and then specifying it, right?
Yeah, absolutely. And I think I've sat where Chris has sat in the chair before, and it's if marketing had a partner that was consistently giving me problems, we got rid of that partner. And I can point to numerous examples, and I don't care how much business they were giving us, because at some point that's not worth the problems, right? And that's I'm sure Chris sees that all the time, and the carriers see that all the time. So you may have 3 strikes, you're out. You may just have 1 big strike.
Yeah, absolutely. Okay, let's shift to questions. That's the question section on the right there. And let's see, we have a few in there. First one, does the CMS recognize the inquiry EBR for 90 days to place the outbound sales call?
No, they do not. That EBR is tied to totally different statute, totally different regulations. It does not in any way impact or apply to CMS's rules.
Okay, yeah, not applicable. That's telemarketing sales rules. That's the FTC. That's a different lens and connection there. Okay. What are the potential penalties or consequences for TPMOs that fail to meet the new CMS compliance requirements by October 1st deadline? Is there a safe harbor period?
There is no safe harbor period. And it's like we just talked about, there's lots of, uh, the penalties can be steep, the consequences can be steep, but there is no official safe harbor period. And again, I'm going to point out that the rule specifically states any personal beneficiary data shared on October 1st or after has to have prior express written consent. And that does not mean that if you got personal beneficiary data on September 30th, you can share it on October 1st without prior express written consent. It means you have to have prior express written consent even on leads generated before October 1st, if you're going to share them after.
Okay, yeah. Let's see, other questions. There's a long one. Let's see, try to unpack this. If you are marketing True Blue Insurance, DCPA gives permissions for only True Blue Insurance can contact me. The call center of True Blue calls, gets the consumer on the line and says, I want to pass you to an agent who can help you in a state that you're in. Do I have permission to transfer you? That would be the question they're asking on the call. So orally, would this meet the rules here?
So a couple of things. One, from a TCPA perspective, again, that agent, okay? Now, hang on, that's a great question because there's a lot to unpack there.
Yeah.
If that agent is an independent agent, let's put it that way, that you're transferring to, that independent agent still has to get consent to call you back. And from a TCPA perspective, from CMS perspective, yes, you can make that transfer, assuming that that agent can immediately help that consumer. And I keep saying that, the immediately help, but that's the language used in the rule, is you can make a transfer if the other party can immediately help.
Yeah. Yeah, that's the big thing is CMS is that carve out that they have, that one unique situation is you call beneficiary because they submitted a lead on your site or whatever, or they called you. I actually can't help you, but I know John can help you. Can I transfer you to John? You have to, if they say yes, you have to immediately transfer them to John. You cannot transfer them anywhere else. Arguably, John can't even transfer them down the line, right? It's just that one-time transfer to John is not covered by the rules. That's the one carve out.
Wow. And so immediate, that's interesting if it uses that term. So does that have the expectation that John is just sitting there and ready and to help, and because he or she can't call back, right? It's not a send to a voicemail process, right?
Right. And so it's and Chris, I think you raised a great point. I think I know I've seen people try to figure out how to daisy chain together. And I don't know that you're going to be able to unless you have like a really good reason for that, right? So let's say that you live in Alabama, I can't write that, so I'm going to send it to somebody who can. Oh, come to find out you need a special coverage in Alabama. Maybe you could send it to a third party, a third person. But without like a real circumstance like that, I don't think that what I call daisy chain would work.
Wow. Another question: does the CMS rule apply to only to the Medicare vertical, or does it apply to ACA? I think that's the Affordable Care Act, right? Because that's also regulated by CMS, right? That's a good.
Yes, it is. But these rules were promulgated under the Medicare marketing communication requirements, so they only apply to Medicare.
Okay, that's a good carve out. Even though CMS does have enforcement authority over that, just to Medicare.
Yeah, they do have enforcement authority over ACA and the marketplace, but these were rules specifically drafted for their Medicare Advantage regulations.
Okay. We've got a question. In your opinion, John, what is the 5-year outlook for TCPA? How strict will these, this is your crystal ball, get it out if it's on the shelf behind you. How strict will these regulations become before the lead generation industry is on life support, even more than it is now? So 5-year outlook from what you're seeing.
This is John Henson's opinion. This is not the opinion of Troutman and me. Maybe, I don't know. But I think what we've seen in the past, let's call it past 3 to 4 years, is a move by companies to be stricter on their definition of ATDS, right? What I mean by that is companies are saying, yeah, what we use may be an ATDS, so we're going to be really very compliant with TCPA. I think what we're going to see in the future, and I think it started with the Facebook case, and it's going to start trickling down. It'll even trickle down faster after one-to-one consent. Is companies are going to go the other way and say, what we're using is not an ATDS or regulated technology, so these rules don't apply to us. We're not going to follow these to the T. It's going to be fine until somebody gets nailed for it. Someone is going to get nailed for the one-to-one consent within the next 12 months, and it's going to be very expensive. And once it starts, that ball will roll very fast downhill. We are already hearing from plaintiffs' attorneys that they're already thinking about ways to attack it. So it's going to be very heavily litigated, and I think it'll be very, very could be very, very bad for the industry as a whole, for people that aren't making sure they're compliant.
Okay. Yeah, and John, is there, if anyone wants to read a little bit more before reaching out to you, obviously directly, where would you point them to get some more information or handouts or any guides for around this whole space?
TCPAworld.com is probably the best place for that. Obviously, we have multiple articles going up every day almost. I write some articles. Chris has written some articles on there. So lots of information about this space on that website.
Yeah, it's a great resource, and yeah, lots of great information from you all for covering this space. It's a main source of information for me, as you all do a great analysis of the coming trends and things like that. Before we close out, I mean, some call to actions. We've talked about a lot of things, but what's the 1-minute takeaway that you want everyone here in the audience to remember? If they only remember of 1 or 2 or 3 things, what is it? Chris?
Well, I mean, number one thing, if you need help on this, call John. Like, seriously, just call him. He will literally hold your hand and guide you. If you're a client of Apollo's, reach out to your account manager. I'm always happy to hop on and discuss regulations and what our plans are and how we can maybe help you buy compliant leads, buy compliant calls. So, I'm always available for that. And understand that unlike TCPA, where you are dealing with the FCC and plaintiffs' attorneys, here you are dealing with CMS and the carriers. The risks are very different, but they are no less severe. CMS is talking to the carriers. Carriers are talking to the downline TPMOs. If a carrier does not like what a TPMO in the chain is doing and feels like it is exposing them to too much risk, they will just kill you off. They will cut you off. You will have no more access to the Medicare vertical. Compliance is literally comply or die. So, just keep that in mind. Take this very seriously, but a flip side of that is there's not plaintiffs with a profit incentive in mind that are knocking you down. Carriers and CMS will be willing to listen to reason. They will be willing to talk to you. So, always keep that line of communication open.
Yeah, excellent. That's right. I mean, plug out to all the compliance officers or those operating in that role. Critically important to help kick off those conversations if they're not comfortable with what they're hearing, or there seems like there's too much uncertainty between the groups, to start proactively reaching out and having those conversations for either outside legal advice or internally with their technology groups, or the languages being used on the pages is critically important. John, key takeaways from you?
Yeah, I would similar to what Chris said, right, is, and I mentioned it earlier, is vendor management. If you are in the compliance department in your company, you're responsible for compliance, go to your marketing teams, go to your sales teams, and have them walk you through the process of the lead. You're a brand new lead. What happens to you from beginning to end? That will help you understand who needs to be listed on the consent pages, what pages you need to be listed on, because a lot of clients are buying and selling leads. So like make sure that when you're buying the leads that you are properly covered. Make sure when you're selling the leads that you're handing them off in a compliant manner, and start reaching out to those partners, your third parties on either side, the buy or the sell side, and say, how are you thinking about this? What can we do to help? And have those conversations too. So it's not just internally proactive, it's externally proactive. Because I think just from conversations that I've had with clients and others, there's a lot of people that have not had those conversations yet. And it's going to be a lot easier to get out ahead of it than it is to catch up.
Yeah, absolutely. Really good advice. Got one poll question. Next, interested in learning more about the services and solutions from Active Prospect or Apollo Interactive or Troutman Amin, please respond to that survey or also from the other communications that we had here if you need help or information about in these areas. Few closing announcements. I'd like to mention the industry association REACH, which is the Responsible Enterprises Against Consumer Harassment. This is the lead industry membership association for lead generation and performance marketing industries. I'm also on the REACH Standards Committee, the Government Affairs Committee, the Technology Committee. So come join the discussion, provide your insights and contributions around these important industry topics that are going to be playing out in the weeks and months ahead. And for membership and information, you can get more information at reachmbc.com. For Active Prospect, the next webinar session is going to be September 11th. That'll be from Dan Lilly, Compliance Officer from Excel Impact. Any events that you or your companies are going to be attending in the next couple of weeks, John or Chris?
We are going to LeadsCon. I think we have in Chicago in September. I'm speaking there. I know Pooja and Eric are also speaking there. And then I think there's some other, but again, TCPAworld.com is the best way to keep up with our comings and goings. You can reach out to me personally on either LinkedIn or email. I'm Henson at Troutman Amin. So feel free to reach out.
Yeah, I won't be going anywhere. The only place I go is Law Conference of Champions every year. So, if you ever want to see me, you better go to that. But we'll have team members at LeadsCon, Contact.io, all those big lead gen conferences.
That's great. Well, thank you both. Really great insight and key takeaways. Obviously, anyone in this space, reach out, start having these conversations. If you don't have these things settled, start the communication up the chain, down the chain, because October 1st is going to be here before you know it. And there is some good advice you can help to mitigate some of this risk. So thank you both for attending, and thank you all.